In contributing to the debate on this bill today, I want to focus my comments on the measures within the bill which relate to the sentencing of child sex offenders, measures which I strongly believe in and which I'm gobsmacked to hear that the Labor Party will be seeking to remove from the legislation by amendment today. I'm one of many Australians who feel that courts across this country have lost their way when it comes to sentencing of child sex offenders. Every week, we read of horrific cases of child abuse where offenders get a suspended sentence or 6 months in jail or just a few years in prison for the rape of a child. These light sentences are wildly out of step with community expectations. They amount to the courts taking a deliberate risk, an unacceptable risk, that a convicted pedophile will abuse a child again in the future. I've spoken on the public record previously about the need for the courts to better differentiate between lower-level crimes and perpetrators of the worst category of crimes, like child sex abuse and terrorism, offences where we should not be releasing offenders back into the community just to test a theory that they might be rehabilitated and won't again cause harm. For property crimes or drug-related crimes, we accept as a community that there is a level of risk when an offender is released, and we tolerate that risk, because it's ultimately in the interests of the community that these people are given a chance to rehabilitate and prove they can live within the law and contribute positively to society. This logic of giving an offender a chance has absolutely no place when it comes to terrorists or people who sexually abuse children. I do not accept that a court should roll the dice on the abuse of children by giving a convicted child rapist a second chance. The risk that an offender may abuse another child because the court speculated on their likely rehabilitation is not a risk we should ever accept. The fact that a convicted pedophile is a risk to children after they release from prison is not contested. That's why we have sex offender registers that record where these offenders live. Those registers are not an academic exercise. They are there to record the names and locations of people we know to be a risk of abusing children again. What kind of system is this, where we catch a person who abuses children, convict them in court, and then let them out again while acknowledging they are still a high risk of harming another child? The only time we can be sure that convicted pedophiles won't harm children is when they're in prison. Yet the courts consistently pass up the opportunity to apply anywhere near the maximum life sentences, even for the most horrific examples. The difference between an offender walking free from court after being found guilty and an offender receiving a 7-year mandatory jail sentence, which this bill provides for with a number of offences, is over 2,500 days in which a predator is in the community and has the opportunity to inflict more abuse on children. This is not a hypothetical scenario. Evidence presented to the Senate inquiry conducted by the Legal and Constitutional Affairs Committee, of which I am a member, shows that in one study, 20% of child sex offenders were caught reoffending again within 6 years. And that's just the ones who were caught and convicted. So in at least 1 in 5 cases, letting a child sex offender walk free can be expected to result in more children being abused, and this should be utterly unacceptable to us as a nation.